Good morning and welcome to the February 11th, 2026 of the Texas Commission on Environmental Quality. It is 9:30 a.m. for the record. I'm Chairwoman Brooke Popp. With me today are our commissioners, Katarina Gonzalez and Tanya Miller, our General Counsel, Mary Smith, and our OPIC, Garrett Arthur. Before we get started, we are going to recognize Garrett. Should I come down and do it? Yeah. Okay. For recognitions. Thank you. All right. As many of y'all know, it's Garrett's last agenda with TCEQ. I get choked up and emotional at these things, but Garrett has been a member of this family for quite some time. We have something in common. We grew up in Plano, although you are a Plano Panther, Plano East Panther, right?
No, I'm a wildcat.
You're a wildcat? Okay, yes. So he's acceptable now because he's a wildcat. He began his career at TCEQ in 1999 as an air attorney in ELD and shortly after moved to OPIC, which has been your home ever since. He's occupied all possible positions in OPIC, from staff attorney to senior for the office and finally public interest counsel. During his time in the office, he's handled numerous cases, helped with transitions and work patterns during and after COVID, which was a doozy, and generally has shown up for the office and the agency. In the near term, he's looking forward to spending more time with his wife and two children, Emmett and Fiona, and I know they'll be so happy to have you home for a while. I don't expect you to stay retired for long. You seem to be one of those that likes to use your brain a lot. So we've very much enjoyed working with you. I only got the pleasure of doing it for a year. Tanya got for 3 months now, 6 months. And Katarina's the senior of the three of us. You have a great work ethic, and your staff love you. You have kindness, and you're brilliant. So you're the whole package. We're really going to miss you.
Thank you.
Thank you. To honor you, we have a proclamation signed by the governor basically saying you're great. And we also have a flag that was flown the Capitol for you. So now it's official. Yeah. Here, let me take this.
Thanks. I don't have a lot to say. I'm really appreciative of what the agency has done for my career and all the friendships and relationships I've made here. And I think that I may miss some of this, but I'll definitely miss all of y'all. And I just appreciate this kind send-off.
Let's scooch this way. Cool. Awesome. Thank you.
All right, onward. Get back to where we are. For each item that argument and discussion is allowed, we'll inform the parties and public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table if you're here in person, or if you're on the webinar, email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our absolute best to accommodate that request. For those making presentations, please wait to begin your presentation until I've asked you to begin speaking, and please check to make sure your line is unmuted before proceeding. So with that, Mary, let's call the first item.
Item number 1 is the consideration of the ALJ's PFD and proposed order concerning the application by Treasure Island Laguna Azure LLC for new TIPD's permit number WQ0016092001. We will begin with the applicant, Treasure Island, followed by the protestant, the city of Van Alstyne, the ED, and then OPIC in that order. Each party will have a time limit of 5 minutes. The applicant may save time for rebuttal as it bears the burden of proof on the application. And with that, we'll begin with the applicant.
Good morning.
Good morning, Chairwoman, General Counsel, Commissioners. I'm Derek Seal with the law firm of McGinnis Lockridge on behalf of the applicant Treasure Island. We have 1,127 acres that we purchased in November 2021. We're planning a residential subdivision with 3,000 single-family houses, 1,500 apartments, and some commercial establishments. As part of that project, as you can imagine, we have to have wastewater service. We tried very hard to reach a deal with the city of Van Alstyne. We couldn't do it, so we ended up in a contested case hearing. The only two issues that were referred by this commission to SOA were regionalization, which this commission seems to discuss a lot these days, and the water quality standards. The briefing that I know the General Counsel and you have all read, I think, does a very good job of explaining what happened in the case. We agree with the proposal for decision. We think the ALJ and the Executive Director got it right in this case, and I will save my time for rebuttal. Thank you.
Thank you very much. Protestants?
Good morning, Chairwoman and Commissioners. My name is Emily Rogers, and I represent the City of Van Alstyne in this matter. The proposed facilities, as Derek mentioned, is intended to serve a development that's in the city's ETJ. The city has an interest in ensuring that the water quality is protected through regionalization and protective permit limits. The city believes this application should be denied because, one, the application fails to comply with this agency's regionalization requirements, and two, the draft permit isn't protective of surface water quality. The Texas legislature has directed this commission to encourage interested and affected parties to cooperate in using regional systems. Providing wastewater service through regional facilities helps protect the water quality of the watershed by limiting the number of potential sources of pollution and help ensure the operational consistency with full-time staff and real-time monitoring. Regionalization shouldn't be a check-the-box exercise with no real consequences. The Commission has the authority and the responsibility to deny a wastewater permit if there's an existing regional wastewater system. And today, this agency should reaffirm that commitment to enforcing regionalization in this case. The city's evidence shows that the city's master planning has included this applicant's proposed project in its plans, and the city's facilities have been sized accordingly. By the fall of 2026, the city will have capacity to entreat the entirety of the 1.4 MGD proposed discharge. And the city is willing to provide wastewater service to the applicant's proposed development and to negotiate terms of service. The city negotiating terms of a development agreement for the development in the city's ETJ and those terms to be beneficial to the city isn't denial of service. The city believes this application should be denied because the applicant has the opportunity to participate in an existing regional system and should be required to connect to the city's wastewater facilities. Also, the draft permit is not protective of water quality. The city's evidence shows that the ED used default coefficients rather than site-specific values in its Qualtex modeling that resulted in an overestimation of the predicted DO levels in the receiving waters. These default coefficients do not accurately capture the stream's geometric characteristics. Incorrect stream characterizations lead to incorrect assessment of impacts of the proposed discharge on water quality. Similarly, the ED's modeling did not consider the channel substrate and the influence of vegetation and vegetation debris on sediment oxygen demand, but instead used default mineral and rocky conditions that aren't reflective of the actual stream. Using recalculated values, more indicative of the site conditions, the city's modified DO modeling predicted low DO concentrations that would produce a stressful environment for the aquatic organisms and detrimental to the creek's aquatic life. The proposed DO limits in the draft permit do not adequately protect water quality in the receiving stream. For these reasons and the reasons provided in the city's closing arguments, and I'm not going to repeat here, the city urges this commission to deny this application. And I'm available for any questions.
Thank you, Ms. Rogers. ED?
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Colin Malley with the Environmental Law Division, and I'm here today on behalf of the Executive Director, and with me are Abdur Rahim, Peter Schaefer, Deb Aduda, and Jim Mahawk. The Commission referred two issues for this hearing: whether the permit complied with the Texas Surface Water Quality Standards and whether it complied with TCEQ's regionalization policy. The ED's witnesses testified to these issues and addressed the permit's technical completeness and compliance with all applicable TCEQ regulations and statutory requirements. The City of Van Alstyne failed to rebut the presumption that the permit met all applicable statutory and regulatory requirements. While the city's experts disagreed with staff's conclusions regarding the application of the permit, the city did not submit evidence that demonstrated staff deviated from established procedures in their respective evaluations related to the water standards or TCEQ's regionalization policy. Upon review of the evidence, the ALJ determined the applicant met its burden of proof, providing the draft permit complies with all applicable legal and technical requirements, and recommended the Commission issue the permit. ED respectfully requests the Commission adopt the ALJ's order and issue the permit. Thank you. Here for questions.
Thank you, Cole. OPIC?
Good morning, Chairwoman Pomp, Commissioner Gonzalez, Commissioner Miller, General Counsel, Executive Directors, Attorney, and staff. My name is Eli Martinez. I'm a Senior Attorney with the Office of Public Interest Counsel for the record. OPIC supports the proposal for decision recommending approval of Treasure Island Laguna Azure LLC's application for new TIPD's permit number WQ00160920001. The permit would authorize phased discharges of treated domestic wastewater up to a daily average of 1.4 million gallons from a proposed activated sludge facility in Grayson County. The contested case hearing focused on two primary issues: whether the draft permit protects water quality, particularly dissolved oxygen levels in the receiving waters, and compliance with the state's regionalization policy. On water quality, the Executive Director's dissolved oxygen modeling used established default hydraulic coefficients, as no site-specific data was required or provided by the applicant. Protestants argued these defaults overestimate dissolved oxygen, but the PFD notes that refinements would require field-measured stream transect data, which are not present in the evidentiary record. The modeling predicts DO levels above the 3 milligrams per liter criterion for intermediate aquatic life use, with a conservative headwater flow assumption that should provide protection even in low flow scenarios. Further, the draft permit's effluent limits align with anti-degradation requirements and the implementation procedures. Regarding regionalization, the applicant complied with Texas Water Code Section 26.081 by demonstrating no economically feasible regional alternative exists. Protestants' exceptions reiterated concerns about DO overestimation and regional options, but the evidence supports the PFD's findings that the applicant met its prima facie burden with no rebuttal sufficient to shift it. This proposed facility would authorize necessary wastewater treatment while upholding water quality standards and regional efficiency, and OPIC therefore recommends the Commission adopt the PFD and issue the permit as drafted. Thank you. I'm available for any questions.
Thank you, Eli. Mr. Steele, you have 3 minutes and 55 seconds remaining, if you'd like to use it.
Thank you, Chairwoman. I'll be brief. I will say I completely agree with Mr. O'Malley when he said that TCEQ did not deviate from any of your normal procedures on the regionalization issue or on the water quality on the water quality issue. I think a lot of the things that the city argued in its briefs, they wanted you to change your policies or your procedures. And if you want to do that, that's fine. But I would urge you not to do it on an ad hoc basis. Go change your policies and procedures if you want a different evaluation of the Texas water quality standards that are not based on default values. You certainly have the discretion to do that, but I would urge you not to do it on an ad hoc permitting basis. With regard to regionalization, Ms. Rogers is exactly right. Your regionalization policy encourages cooperation. That's what we did. We didn't check a box. Even before we closed on the property in April of 2001, we approached the city about wastewater service. We negotiated with them for wastewater service through January 2024. We couldn't get there. They wouldn't give us wastewater service without conditions. They wanted annexation. The city manager wrote a letter that we put in the record that said, we're not going to give you service unless you annex. And there were a lot of other conditions. Therefore, we didn't need to do a cost analysis. But there is evidence in the record, and I want to just go through very quickly what it would have cost for us to comply with the terms of the development agreement that we were trying to negotiate. The density requirements through annexation alone would have cost $10 to $12 million more. The development agreement would have required us to construct a fire station for $5 million and then give it to the city. There would have been a public improvement district fee of $3.5 million. A park fee would have been $4.4 million. Lots of masonry requirements and other construction requirements would have required us to increase the cost of our product and made the cost of our houses and our apartments more expensive. And in addition, we would have had to pay over $16 million in wastewater impact fees to connect to their system, not to mention the easements, the pump stations, and all the other things. So for those reasons, Commissioners, I would urge you to adopt the ALJ's PFD in their proposed order. And I'm happy to answer any questions.
Thank you, Mr. Seal. All right, before us is a PFD and proposed order concerning an application by Treasure Island Laguna Azure LLC to authorize a new wastewater treatment facility in Grayson County. I've reviewed the record and the ALJ's analysis and recommend granting the TIPD's permit. My evaluation, I find that the evidence in the record supports the ALJ's determination that the applicant met its burden to establish that the draft permit is protective and meets all applicable requirements. So I would adopt the ALJ's proposed order. I would also make the following minor revisions and clerical changes to the proposed order. On page 1, in the summary paragraph, I would add that the applicant is referred to as Treasure Island. I would revise finding of fact number 14 to add the word minimum before DO to be consistent with the draft permit. In finding of fact number 38, I would replace White's Prong Creek with West Prong Whites Creek. Now I will stop there and see where my colleagues are.
I'm in agreement. I also think the ALJ correctly determined that the draft permit is protective of water quality, including the protection of drinking water because it complies with the Texas Surface Water Quality Standards under Chapter 307, and in agreement with your changes.
I'm in agreement as well.
Wonderful. I move that we adopt the ALJ's proposed order with the following changes. On page 1 of the proposed order, add that the applicant is also referred to as Treasure Island. In finding of fact number 14, add the word minimum before DO. And in finding of fact number 38, replace White's Prong Creek with West Prong Whites Creek. 2, issue the draft permit as recommended by the executive director. And 3, adopt the ED's response to comments.
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
Item number 2 is the consideration of the ALJ's PFD and proposed order concerning the application by Jerton LLC for new TIPD's permit number WQ 0016336001. The parties have been notified that the applicant, the protestants, collectively, the ED and OPIC will each have 5 minutes of oral argument time. The applicant should speak first and may reserve a portion of its time for rebuttal as the applicant bears the burden of proof on this matter. So that will begin with the applicant. I believe we have Mr. Walker.
Good morning. Curran Walker from Greg Law, PC, on behalf of the applicant. We believe this PFD was correctly decided. It is supported by commission staff and by OPIC. And although challenge was made to the application, the ALJ correctly considered all the issues in light of the evidentiary record and recommended issuance of the permit. I'd like to reserve the balance of my time for rebuttal unless there are any questions.
Short and sweet. Thank you, Mr. Walker.
Thank you.
We'll hear from the protestants.
Good morning, Chairwoman and Commissioners again. My name, for the record, is Emily Rogers, and I represent protestants Ellis County and the City of Waxahachie in this matter. The city and the county have an interest in ensuring water quality is protected through appropriate permit limits. This area of Texas is facing rapid growth, and with that growth, a proliferation of wastewater treatment plants. The county and the city are concerned about the cumulative impacts that these plants will have on the water quality in the region. And for this reason, there should be a careful review of these applications each time, which we don't believe really happened in this case. The application should be denied because the proposed discharge is not protective of water quality. The draft permit, the ED's modeling didn't take into account site-specific data that would have been important to accurately determine the actual impact of the proposed discharge. The default values used in the ED's modeling did not adequately represent expected flows of the receiving stream in the ponds and the width of the receiving stream. With no site-specific data, the ED determinations regarding depth values were based on best professional judgment. The ED's witness even admitted that the default hydraulic coefficients may not be a great fit for the receiving stream. The city's and the county's evidence showed that the use of default parameters resulted in underestimated dissolved oxygen predictions, which will be detrimental to aquatic life and water quality. The TCEQ's review should consider the impacts of the discharge of this particular receiving stream in Ellis County, not the impacts of the proposed discharge on a hypothetical Texas stream. Additionally, the ED did not use the correct model to analyze the impacts of the ponds on the receiving stream. The CSTR modeling should have been used for the ponds along the discharge route instead of the Qualtex model. The ED's witness stated it was a judgment call as to which model to use, but admitted that using the Qualtex model was more expedient and used due to workload-related reasons. Interestingly, the applicant's witness testified that both the ED's and the city's and the county's modeling were both flawed. This further evidence demonstrates the draft permit doesn't meet the applicable requirements instead of supporting the ED's and the applicant's position. Again, with the proliferation of wastewater treatment plants in Ellis County, careful review and site-specific analysis is warranted. That didn't happen in this case. For these reasons and all the reasons we've provided in our closing arguments, the city and the county urge this commission to deny the application. Thank you.
Thank you, Ms. Rogers. Edie?
Good morning, Chairwoman.
One second.
There were multiple protestants in this matter. She used part of the time, and I was going to use the remainder.
Excellent.
Okay.
Can you state your name?
Yes, my name is Eric Allman, here on behalf of Citizens Against Butcher Road Mud. Good morning, Chairman, Commissioners, General Counsel, and Office Public Interest Counsel. Citizens Against Butcher Road Mud includes a number of members, including, for instance, Dr. Abdul Bader, who owns property adjacent and immediately down gradient from the property. As a medical doctor, he realizes the dangers that this facility could pose. His property frequently floods due to flooding from the facility. Clay Estes owns a farm immediately downstream from the property. Raymond Smith enjoys fishing in Lake Clopton, immediately downstream. Citizens Against Butcher Road Mud have two primary concerns regarding this application. First, TCEQ 309.12.4 requires the consideration of climatological conditions in determining whether the application minimizes the contamination of surface waters. That analysis was not performed here. Dr. Abdul Bader's property will flood due to water running off of this facility, and it was not shown that that would be minimized. The topographic map shows him to be downgrading the property. Adjacent landowner's map shows him to be immediately adjacent to it. This evidence was not considered by the administrative law judge. This heightened potential for contamination of his property should be considered and addressed. In addition, the receiving water is really just a small ditch, so it will not be diluted as it travels down to a pond downstream. That pond, there's been no evaluation as to whether excessive algal growth would occur within that pond. The executive director's staff admitted there was certainly the potential for that to happen, and yet that simply was not analyzed to determine whether that general criteria was met, which is in addition to the Tier 1 review and the Tier 2 review. And for those reasons, Citizens Against Butcher Road Mud, and of course I'll note, we certainly agree with each of the modeling errors noted by the citizens by Ellis County and the city of Waxahachie. For those reasons, Citizens Against Butcher Road Mud ask that the permit be denied. Thank you.
Thank you, Mr. Walker. Edie?
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. For the record, I am Michael Parr with the Environmental Law Division. With me today is Rishang Zhang of the Water Quality Division, Peter Schaefer, James Mahawk, and Deepa Dutta, also of the Water Quality Division. The Executive Director supports the Administrative Law Judge's conclusions and findings as referenced in her PFD in order that the applicant has met its burden of proof on the issues and that the draft permit should be issued. The ALJ found no party tendered any evidence to rebut the prima facie presumption that the draft permit meets all applicable legal requirements and technical requirements, and if issued, will be protective of human health and safety, the environment, and property. Instead, the ALJ found the uncontroverted evidence in the record established that the applicant had met its burden regarding the issues developed in the record. The ED recommends adoption of the ALJ's PFD in order with the minor correction of finding of fact number 9. This error was discovered after the ALJ had issued her exceptions letter. The Executive Director recommends the Commission amend finding of fact number 9 so that it reads that the draft permit's final phase dissolved oxygen limit is 6.0 milligrams per liter and not 4 milligrams per liter as it currently reads. This amendment would be consistent with the PFD's effluent limit tables on pages 7 and 8 and accurately reflects the minimum dissolved oxygen limit in the final phase of the draft permit. Thank you, and we are available for questions.
All right, thank you. Any questions for Edie? OPIC?
Good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's attorney and staff. For the record, I'm Pranjal Mehta with the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and recommends that the draft permit be granted without any changes. We participated in the hearing, evaluated the evidence and arguments presented, and concluded that the applicant met its burden of proof in this direct referral case to show that the application complies with all applicable statutory and regulatory requirements. For the issue of dissolved oxygen modeling, based on the record and expert testimony, OPIC finds that the ED's analysis is consistent with TCEQ rules and standard operating procedures and is supported by the record. OPIC also finds that the use of default hydraulic parameters was proper under TCEQ procedures in the absence of site-specific field data and ensures consistency and fairness across permit reviews statewide. OPIC understands the concerns regarding anti-degradation, aquatic vegetation, and siting raised by Citizens Against Butcher Road Mud. However, we concur with the ALJ that the protestants that the protestants must present evidence demonstrating that one or more provisions in the draft permit violate a specifically applicable state or federal requirement. Therefore, OPIC agrees that the protestants failed to rebut the prima facie demonstration on these issues. For these reasons, OPIC supports adoption of the proposal for decision and issuance of the permit. Thank you, and I'm happy to answer any questions.
Thank you, Pranjal. Oh, Mr. Walker, you have 4 minutes and 42 seconds remaining should you choose to use it.
Thank you. All of the issues raised today are addressed in the PFD. They were urged again in exceptions, and the ALJ again considered them and noted these have already been addressed in the PFD. We believe that that PFD is correctly decided, that those issues that have been argued today are correctly decided in the PFD. Be happy to answer questions.
Thank you.
Thank you, Chairwoman.
Well, before us is a PFD and proposed order concerning an application by Jerrickton LLC for a new wastewater discharge permit. In my review of this matter, I found that the record supports the ALJ's determination that the applicant has met its burden and the draft permit will meet all applicable legal and technical requirements, including protection of water quality and siting requirements. I'm prepared to adopt the ALJ's proposed order with minor modifications. First, I noted what appears to be a clerical error in 2 of the effluent limits regarding the final phase of the draft permit and finding of fact 9. The draft permit and the PFD state that the limit for dissolved oxygen is 6.0 milligrams per liter, and the maximum total chlorine residual, is 4.0 milligrams per liter in the final phase. However, these values appear to have been interchanged in finding of fact 9 of the proposed order. I plan to propose modifications to the dissolved oxygen effluent limit and the maximum chlorine residuals so they reflect the limits that are in the draft permit. However, before I fully propose the modifications to the effluent limits, I'll stop and ask if the party representatives have any objections to these changes. Any objections? All right. I'd also propose an addition to finding of fact number 17 to clarify that the administrative record was admitted into evidence. I also noted some clerical errors within the permit number I propose we correct, and I would add an ordering provision to clarify that the Commission's intent to issue the permit. Finally, I reviewed the ED's response to comments and would propose that we adopt that document. Colleagues, if we're on the same page, I'll make a motion.
We're on the same page.
I just want to point out that, because it came up again, that the modeling in this case was done appropriate and consistent with our procedures, and that the ALJ in this case evaluated the expert testimony and didn't find that the protestant's expert testimony was persuasive. And then I'm in agreement.
Good point. All right, I move that we grant the application of Jerrickton LLC for a new TIPD's permit number WQ001-633-6001 and issue the permit in the form recommended by the Executive Director. Adopt the Administrative Law Judge's proposed order with the following modifications. To clarify that the administrative record was admitted into evidence, add the following sentence to finding of fact 17. The administrative record was admitted into evidence. To correct clerical errors in the description of the effluent limits in the final phase of the draft permit in finding of fact 9, replace the value of 4.0 regarding the dissolved oxygen effluent limit with 6.0, and replace the value of 6.0 regarding the maximum chlorine residual with 4.0. Correct the permit number throughout the order to clarify that the Commission's intent is to issue the permit, add ordering provision 1.a to state the permit is issued in the form of the draft permit as recommended by the Executive Director. Do I have a second?
Do we also want to adopt the Executive Director's response?
Yes. And I move that we adopt the Executive Director's response to comment. Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. All right. Give everyone some time to shuffle.
Item number 3 is the consideration of the ALJ's PFD and proposed order concerning the application by Clear Utilities LLC for new TIPD's permit number WQ00163600001. The order of presentation will begin with the applicant, followed by the protestant, the ED, and OPIC. By letter dated January 23rd, 2026, the parties were notified that each will have 5 minutes of oral argument time. The applicant may save time for rebuttal as it bears the burden of proof on the application. And with that, we'll begin with Mr. Walker again for the applicant.
Good morning.
Good morning again. I'm Curran Walker on behalf of the applicant, Clear Utilities. This proposal for decision was correctly decided, supported by commission staff and OPIC. We believe the ALJ correctly considered all the issues and the evidence presented at hearing and reached the right result in the proposal for decision. Happy to answer any questions.
Any questions for Mr. Walker? All right.
Thank you.
you. We'll hear from the protestant.
And I will say that nobody's registered on behalf of the protestant.
Right, we'll move on to the executive director staff.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Fernando Salazar Martinez of the Environmental Law Division, and I'm representing the Executive Director. With me today are my colleagues from the Water Quality Division, Sonia Buya, Deba Duta, Jim Machok, and Peter Schaefer. The Executive Director recommends the Commission adopt the Administrative Law Judge's proposal for decision and proposed order and issue the draft permit without changes. The Executive Director agrees with the Administrative Law Judge's findings of fact and conclusions of law as referenced in the proposal for decision on referred issues 1 through 3 and the 4th issue added by the ALJ for Zoe's consideration. After examining the evidence in the record, the ALJ found that the protestants' concerns regarding water quality do not show any violation of a legal or technical requirement, and the applicant met its burden of proof on water quality. The applicant satisfied TCEQ's rules regarding odor abatement by establishing a buffer zone. The protestants did not have specific evidence providing overriding odorous conditions, and the applicant met its burden of proof on odor. The protestants did not present evidence about human health concerns, and the applicant met its burden of proof on human health, and the applicant complied with the applicable public notice requirements and met its burden under the applicable rules of 30 Texas Administrative Code, Chapter 39. In conclusion, the Executive Director respectfully requests that the Commission adopt the ALJ's PFD and proposed order, and issue the permit without changes. Thank you, and we're available for any questions.
Thank you very much. OPIC?
Hi, good morning, Chairwoman, Commissioners, General Counsel, and the Executive Director's attorney and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. With respect to the Commission's consideration of the proposal for decision and related record in this matter, after participating in the hearing on the merits and examining the evidence and argument presented, OPIC maintains the position taken in our closing brief, that the applicant met its burden of proof and that the application and permit have been shown to comply with applicable statutory and regulatory requirements on the issues considered during the contested case hearing, including the issue of whether proper notice was provided to adjacent and downstream landowners, which was added by the Administrative Law Judge during the contested case hearing. Thus, in OPIC's view, the permit should be issued. With regard to the highly contested issue of notice, OPIC found that the greater weight of the evidence demonstrates that the applicant has substantially complied with applicable notice requirements. Here, protestants allege that the applicant improperly sidestepped notice requirements. Prior to the submission of the instant application to TCEQ, the developer of the property, Field Creek Crossing LP, conveyed the land that is proposed for the site of the wastewater treatment facility to Clear Utilities LLC. the entity that will operate and maintain the facility. Owing to this conveyance, the only adjacent landowner that applicant provided mail notice to was the developer, Field Creek Crossing LP. Had this conveyance not taken place, applicant would have been required to notify landowners who have properties that lie adjacent to the property owned by the developer. Excuse me. Protestants argue that this arrangement resulted in the exclusion of adjacent landowners and limited public participation in violation of TCEQ rules. In response, applicant argues that the application complies with all applicable notice requirements. It explains that because Field Creek Crossing owns all of the land surrounding applicant's property, only Field Creek, as the adjacent landowner, was entitled to mailed notice. In OPIC's view, based on the evidence presented here, we cannot find that applicants' actions rise to a level that would justify permit denial. We certainly recognize the concern that a developer could engage in gamesmanship, intended to limit the number of people notified of an application. By providing mailed notice to less potentially affected persons, an applicant may be able to avoid or lessen public participation in formal opposition to its permit application. While this concern is substantial, the record here does not indicate any violation of an applicable notice requirement. There are no TCEQ rules or applicable statutes that specifically prohibit the property conveyance that took place here. Further, though mailed notice to protestants was not required, and they did not receive mailed notice, protestants have fully participated in the contested case hearing process, which afforded them a full and fair opportunity to scrutinize this application and draft permit. Therefore, while OPIC appreciates the concerns and participation of the protestant parties, OPIC finds that the greater weight of the evidence demonstrates that applicant has substantially complied with applicable notice requirements. OPIC further found that the applicant met its burden of proof on the other issues considered in the hearing. As such, we respectfully recommend adoption of the proposal for decision and issuance of the permit. Thank you, and I'm available for any questions.
Thank you, Sheldon. Mr. Walker, you have 4 minutes and 40 seconds. All right. Ladies, I've reviewed the record in the ALJ's PFD and the proposed order and agree with his recommendation that the applicant met its burden in this matter and the permit should be issued. So I would adopt the order with a few minor revisions. I would revise the order to correct the date that the Commission issued its interim order in this matter and clarify that we are issuing the permit and adopting the ED's RTC. Finally, I would add a new finding of fact to note that the other requirement, number 3, in the draft permit requires the permittee to submit evidence of legal restrictions prohibiting residential structures within part of the buffer zone not owned by the permittee prior to the construction of the facility. I'll stop here and see what y'all think.
I'm in agreement.
In agreement.
Do you have a motion?
I move that we adopt the ALJ's proposed order with the following revisions. Amend finding of fact number 27 to state, on December 18, 2024, the Commission considered the hearing request at its open meeting and on the same day issued an interim order granting a hearing request and referring 3 issues to SOA. To clarify, the Commission issued its interim order on December 18, 2024. That we add new finding of fact number 44A to state, other requirement number 3 in the draft permit requires the permittee to comply with the requirements of 30 Texas Administrative Code, Section 309.13E, prior to construction of the facility and submit evidence of legal restrictions prohibiting residential structures within the part of the buffer zone not owned by the permittee. To clarify the evidence in the record regarding how the buffer zone requirements will be met. C, amend ordering provision number 1 to include the phrase, and the permit shall be issued, to clarify that the Commission is issuing the permit to the applicant. And D, add new ordering provision number 2A that states the Executive Director's response to comments is hereby adopted pursuant to 30 Texas Administrative Code Section 50.117F. That we issue the ED's draft permit and that we adopt the ED's response to comments.
Do I have a second?
A second.
All those in favor say aye. Aye. Motion passes. Thank you.
Oh, yeah, it's bad.
So Item number 4 is the consideration of the application by Enbridge Ingleside Oil Terminal, LLC for water use permit number 13775. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Before us, we have an application by Enbridge Ingleside Oil Terminal, LLC for a new water use permit to divert 500 acre-feet of water per year from a diversion reach on Corpus Christi Bay. The Commission received numerous hearing requests, and there has been significant public interest in this matter. After reviewing the record and all of the individual and group hearing requests filed in this matter, I do not see any requester that demonstrated that they are an affected person by establishing a personal justiciable interest that is different from the general public under applicable rules. Therefore, I deny all hearing requests. Commissioners?
I'm in agreement.
I'm in agreement.
Do I have a motion?
I move that we deny all hearing requests and issue water use permit number 13775 to Enbridge Ingleside Oil Terminal, LLC, as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye. Aye. Motion passes.
Item number 5 is the consideration of the application by CCEQ Concrete of Lubbock for air standard permit number 176227. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
All right, CCEQ Concrete of Lubbock has applied for a standard permit to authorize the use of an existing concrete batch plant in Lubbock County. The previous authorization for this plant expired on March 15th, 2024. In reviewing the hearing request, I find that the North and East Lubbock Coalition failed to demonstrate that it has a member that meets the statutory requirements for affected person status for concrete batch plant standard permit. In addition, I did not find a basis to grant the request for reconsideration because the issues raised in the request relate to potential future enforcement of the standard permit. Therefore, I deny all the hearing requests and request for reconsideration in this matter. Colleagues?
I agree.
I agree as well.
Do I have a motion?
I move that we deny all hearing requests and requests for reconsideration, that we adopt the Executive Director's response to comment, and that we issue the permit as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you.
We're on your way to healing.
Item number 6 is the consideration of the application by Logan X Ready Mix LLC for issuance of air quality standard permit for concrete batch plant registration number 179939. The parties have been notified that the commissioners will not take oral argument but may ask questions.
Apologies for the croaky voice, y'all. Cedar fever has me bad today. For this item, we have a registration application for coverage under the air quality standard permit for a concrete batch plant, which would authorize the construction and operation of a permanent truck mixed concrete batch plant in Wise County. The Commission received a number of hearing requests for this item. When considering hearing requests for these items of application, the Commission follows a two-step process to first determine effectiveness and then which issues should be referred to SOA. Additionally, for these type of applications, the legislature has directed the Commission to consider only those individuals actually residing in a permanent residence within 440 yards of the proposed plant as affected persons. In this case, Danny, Donna, and Keith Meyer reside within 440 yards of the proposed facility, filed timely comments, and explained in their hearing request how they would be affected by the application in a manner that is different from the general public. Therefore, I would grant the Myers a hearing. The remaining requesters didn't file timely comments during the comment period. Also, their form petition didn't explain how they would be affected by the application in a manner different from the general public. Therefore, I would deny their hearing requests. And I will stop here and see what my colleagues think.
I agree. I think that the Myers, they're within the distance. I think that the other requests either were too far away or they didn't properly assert a personal justiciable interest with the form letter.
I am in agreement.
All right, let's move on to the referral of issues. In their hearing requests, the Myers raised relevant and material issues concerning health, safety, air quality, and the permit's protectiveness of vegetation, animal life, and the environment. These issues are within our jurisdiction in this matter, so I'd refer these issues to SOA. Finally, I'd recommend a 100-day hearing duration. Colleagues?
I also agree.
Do I have a motion?
I move that we grant the hearing requests of Danny, Donna, and Keith Meyer, that we deny the remaining hearing requests, that we refer the application to SOA for a contested case hearing concerning the following issues: whether the permit is adequately protective of the health and safety of the requesters, including sensitive subgroups, whether the permit is adequately protective of air quality, and whether the permit is adequately protective of vegetation, animals, and the environment, and specify that the maximum duration of the hearing is 180 days from the preliminary hearing to issuance of the proposal for decision.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Thank you. Moving along.
Item number 7 is the consideration of the adoption of the renewal with amendment of TIPD's general permit TXG130000 to authorize the discharge into or adjacent to water in the state by aquaculture facilities. And the executive director's staff is here to present this item.
Good morning, Madam Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Shannon Gibson with the Water Quality Division. With me today is Michael Parr with the Environmental Law Division. Staff requests adoption of a renewal with amendment of the Texas Pollutant Discharge Elimination System Aquaculture General Permit, TXG 130000, which authorizes the discharge of wastewater generated as the result of activities at aquaculture facilities and other activities related to aquaculture into or adjacent to water in the state. The proposed permit will replace the current permit when it expires on April 18th, 2026. In addition to cleaning up general language, clarifications, and notification requirements, the proposed amendment also implements House Bill 609 from the 89th regular legislative session. This bill added Section 26.0406 to the Texas Water Code, which allows a holder of an cultivated oyster mariculture permit under Chapter 75 of the Texas Parks and Wildlife Code to discharge wastes related to cleaning of growth structures for cultivated oysters. The bill requires cleaning activities to be conducted on location using in situ water and without the use of soap or chemicals. This amendment authorizes the cleaning of growth structures for cultivated oysters in or over water in the state and establishes requirements to ensure cleaning activities are conducted in a manner that is protective of water quality. The draft permit was sent to the United States Environmental Protection Agency for their review on March 19th, 2025, and on May 27th, 2025, TCEQ received a no objection letter with approval to proceed with the issuance of the draft permit. Public notice of the draft permit was published in the Houston Chronicle and the Texas Register on August 22nd, 2025. A hybrid virtual and in-person public meeting was held at TCEQ on September 22nd, 2025. The public comment period closed on September 22nd, 2025, without any public comments received. Staff respectfully recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions necessary to comply with Texas Register requirements. Thank you, and we are available to answer any questions.
Thank you. Any questions for ED? Nope. All right, is anyone signed in on this issue?
No one signed in on this one.
Okay. OPIC.
Good morning again, Chairwoman, Commissioners, General Counsel, Executive Directors, Attorneys, and staff. My name is Eli Martinez with Office of Public Interest Counsel for the record. We've reviewed the renewal with amendment of TIPD's General Permit TXG 130000. This permit authorizes wastewater discharges from aquaculture facilities and related activities into or adjacent to water in the state, replacing the current version set to expire on April 18th, 2026. The permit is thoughtfully structured into 5 levels of authorization, tailored to the scale and risk of operations, from low-impact Level 1 activities like retail bait dealers and public aquariums, which require no notice of intent, to larger facilities in Levels 2 through 5 that do. A key amendment implements House Bill 609 from the 89th Legislature, adding Section 260406 to the Texas Water Code. This allows Level 5 oyster mariculture facilities to conduct routine in-situ cleaning of growth structures without soaps or chemicals, provided it avoids equipment damage and significant turbidity changes. This practical adjustment supports the industry while protecting our coastal waters. OPIC particularly appreciates the enhanced environmental safeguards. For Level 5, the permit mandates best management practice plans addressing solids controls, material storage, structural maintenance, record keeping, and training, and prohibits feeding in net pens to minimize suspended solids and oxygen-demanding pollutants, going beyond federal requirements in 40 CFR Part 451. Groundwater protections have been strengthened with clear nitrogen and phosphorus loading rates, weekly monitoring, bilingual signage, and secure irrigation systems, and administrative updates like clear definitions and streamlined reporting via email or NetDMR improve clarity without added burdens. Fees to permittees remain reasonable. $100 NOI application fee and annual water quality fees of $100 for Level 2 or $250 for higher levels. The development process contained a high degree of transparency. Preliminary outreach to current permittees yielded no comments. The Texas Parks and Wildlife Department reviewed the draft for 45 days with no suggested revisions, and the EPA issued a no objection letter after clarifications. Public notice appeared in the Texas Register and Houston Chronicle on August 22nd, 2025, with a hybrid meeting on September 22nd, yielding no comments from the public, indicating broad consensus and no anticipated controversies. In terms of impact, this renewal poses minimal burden on the regulated community, with just 56 current authorizations and no significant increase expected. Existing permittees simply renew their NOIs within 90 days, and the public benefits from sustained water quality protections with no adverse effects. An agency workload avoids the strain of issuing individual permits. In conclusion, OPIC believes the permit meets all statutory requirements under Texas Water Code Section 26121, 26027, and 26040, upholding the Commission's mission to protect Texas environment and public health while fostering sustainable aquaculture. We recommend adoption as proposed to ensure seamless continuity, and I'm available for any questions.
Thank you very much. I appreciate the work that's gone into this legislative implementation project and the renewal generally of this permit. I especially applaud the collaboration with both Parks and EPA. I'm prepared to move forward with adoption. Colleagues?
Same. Yeah, I agree with the changes and believe it appropriate implements the House Bill 609 changes. So in agreement.
Do we have a motion?
I move that we adopt the renewal with amendment of Texas Pollutant Discharge Elimination System General Permit Number TXG 130000 as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you. Moving on to item 8.
Item number 8 is the consideration of the petitions for inquiry filed by Kelly Lane Harlan, Scott Barraza, Wesley Wright, and Tommy Sue Arnold, seeking review of the Corpus Christi Aquifer Storage and Recovery Conservation District. The petitioners should go first, followed by Corpus Christi Aquifer Storage and Recovery Conservation District. Other response filing districts, presently I don't believe we have any signed in. Any interested persons, we have 2 interested persons signed in, the ED and then OPIC. The parties will each have 5 minutes of oral argument time. Petitioners collectively will have 5 minutes and may save time for rebuttal as they bear the burden of proof on their petition. So with that, we'll begin with Kelly Harlan, the petitioners.
Good morning.
Good morning. Good morning, Commissioners. My name is Kelly Harlan, and I'm here as a petitioner regarding a petition for inquiry involving CCA-SRCD. I want to begin by being direct. In our initial filing, we did not include all supporting documentation. Based on our understanding of the petition for inquiry process at the time, we believe the evidence would be provided later. If we're unsuccessful today, we fully intend to refile and supplement the record with the proper documentation. However, that procedural shortcoming is minor when weighed against the ongoing groundwater impacts and the risk of allowing irreversible actions to proceed without review. Yesterday, the Corpus Christi City Council approved a new purchase of groundwater rights tied to land and it's next to its western well field, expected to produce at least 15 million gallons per day. This approval substantially accelerates pumping while statutory and planning questions under Chapter 36 remain unsolved. As documented in the CCA-SRCD's own groundwater management plan, total modeled available groundwater for Nueces County is on the order of roughly 7,000 acre-foot per year, while 15 million gallons per day equates to approximately 16,800 acre-feet per year. That single project alone illustrates the magnitude of inconsistency identified by Mr. Cranford and Mr. Graham. This situation is moving very fast. Groundwater infrastructure decisions with long-term and irreversible consequences are not hypothetical. They are being implemented right now. At a public town hall, City Manager Peter Zanoni acknowledged that the city previously pledged there would be no additional drilling beyond 2 well fields, but later reversed course, stating it would be foolish not to access available groundwater despite prior commitments. That statement highlights the issue before the Commission today. Chapter 36 exists to protect groundwater resources through planning, desired future conditions, modeled available groundwater, and conservation duties, not to relax protections when supply pressures increase. The concerns raised here directly implicate multiple grounds listed in 36.311B. First, under 36.311B2, 7, and 8, there are serious questions about whether the district's rules and permitting framework are desired and enforced to achieve adopted Region 16 DFCs and protect groundwater resources. Pumping capacity continues to expand without demonstrated consistency with those limits. Second, under 36.3011B 5, 7, and 9, planning is reacting to development rather than guiding it. The city advances groundwater infrastructure, seeks city council approval, and then obtains district authorization through the CCA-SRCD after the fact, rather than through independent prospective regulation. Local reporting confirms that at the Blunser site, access roads, electrical infrastructure, and an initial well were constructed before the city's purchase were even approved, reinforcing the concern that regulation is following development rather than guiding it. As City Manager Peter Zanoni has publicly stated, when new well fields are proposed, it would be recommended that the landowner petition for inclusion into the CCA-SRCD's boundaries, after which the CCA-SRCD board would have a final sign-off on how much water the city could pump. That process places regulatory approval after development under a board appointed by the city itself. That concern is heightened by the governance structure itself. Mr. Zanoni, as city manager, directly supervises the CCA-SRCD's general manager and city employees who serve on the district board, placing the city's water supply priorities and the district regulatory decisions under the same management authority. Third, under 36.3011B 8 and 9, the district's own rules prohibit waste and require protection of groundwater, yet groundwater produced from these well fields is conveyed to surface waters, permanently removing it from an aquifer that recharges at only fractions of an inch per year. Detailed supporting documentation has been provided in your packet by Mr. Cranford and Mr. Graham. We're not asking the Commission today to decide the merits or to impose enforcement action. We're asking the Commission to do exactly what 36.3011 provides for, to refer this matter to a review panel so these issues can be examined independently and on a complete record before additional irreversible groundwater commitments are made. If review is delayed, oversight becomes meaningless after the fact. Groundwater development does not pause while this procedure unfolds. For these reasons, we respectfully request referral of the petition for inquiry to a review panel. And thank you for your time and consideration, and I'm here to answer any questions you have. Thank you.
Thank you, Mr. Harlan. Mr. Gershon?
Chairwoman Pop, Commissioners Gonzalez and Miller, Ms. Smith. My name is Mike Gershon with the law firm of Lloyd Gosselink here in Austin on behalf of the district. Also with me in person is the district's general manager, Steve Ramos. It is rare that the commission has presented a petition for inquiry. The inquiry statute and TCEQ's rules were enacted to create a mechanism to ensure accountability by groundwater districts. A petition is appropriate to address non-functioning districts. The Corpus Christi district is sophisticated, it is well-funded, and it is fully functioning. The 4 individuals who independently submitted petitions request that you look at 3 or 4 key of the 9 mandates that are set forth in your rules in the statute. Those 4 mandates require that a district submit a management plan to the Water Development Board, coordinate in the GMA, Groundwater Management Area planning process, and have rules in place designed to achieve desired future conditions and that protect local groundwater resources. The applicable standard of review is that straightforward. The proof of the district's compliance is evident from the record. On file are exhibits that include a sworn affidavit from Mr. Ramos, our management plan that was submitted to the Water Development Board, correspondence with the Water Development Board, and our rules. This information reflects that the district's management plan was readopted and appropriately submitted, that the district actively participates in the work of the local GMAs, 15 and 16, that its rules in place are designed to achieve DFCs and to protect local groundwater resources. We appreciate your executive directors and Office of Public Interest Counsel's thorough written analysis and their comments that have been reduced to writing. That analysis confirms that the district is satisfying the referenced statutory mandates. The petitioners cannot and the petitioners have not shown otherwise. When you distill their nearly identical petitions, it's apparent that they're not really challenging whether the district has a management plan and is functioning with rules in place. There is a backstory that you have heard from one of the petitioners today. There is concern about local impacts to water resources. We recognize that. We also recognize that the petitioners disagree with the approach of the district on policy and how it's regulating. And we understand that the petitioners are distrustful of the relationship between the city and the district. But that relationship was established by statutory mandate of the Texas legislature when the district was created 20 years ago. And there is substantial work of many important stakeholders, public and private, on water supply and water demand challenges in the region. We recognize that. But it is a misread of the inquiry statute, 36-3011, that the petitioners, for the petitioners to attempt to affect local permitting and policy through your office here today. There are other legal remedies for them to do so. Most importantly, their ability to protest permit applications that they have complained about here today and in their written submission. They can participate in the rulemaking of the district and the groundwater management areas business. The remedies under the inquiry statute that the commission has are drastic. You dissolve the district. You dissolve the district's board. You appoint a receiver. Or you enter an enforcement order instructing the district to comply with statutory mandate. These all make clear of the legislature's intent to allow TCEQ oversight and to address situations where a district has been woefully negligent and does not have an adequate regulatory program in place. The inquiry process is not designed to target districts that are fully functioning with rules that are actively engaged with regional planning at the GMA level.
The statute doesn't provide for TCEQ to get into the policy decisions of the districts as statutorily mandated. To grant the petition would be wasteful of TCEQ's resources to go through a several-month review panel process. It would be wasteful of the resources of the panel, of the district, and other key stakeholders, many which include public, private utilities, and other public and private stakeholders who are expending substantial resources working the supply and demand challenges. On their face, the petitions fall well short of the burden in your rule, 293.23, and the inquiry statute.
That's time.
In closing, we respectfully request the Commission dismiss the petitions. Thank you for your consideration.
Thank you, Mr. Gershon.
Okay, next we have interested persons, and the first one on my list is Trey Cranford.
Is he online?
Good morning.
Good morning.
Good morning. Good, you can hear me. Madam Chair and Commissioners, good morning. My name is Trey Cranford, and I am a landowner within GMA 16 and an affected person under Texas Water Code 36.3011. I respectfully ask the Commission to grant the petition for inquiry and appoint a review panel. Because the evidence demonstrates that multiple statutory conditions under 36.3011B are implicated and warrant independent examination. Chapter 36 establishes 9 exclusive grounds for inquiry. This matter squarely raises concern under at least 3 of them. First, 36.3011B7, whether the rules adopted by the district are designed to achieve the adopted DFCs. The model available groundwater from Nueces County is 6,787 acre-feet per year. The city of Corpus Christi is already producing approximately 8,961 acre-feet per year and has publicly stated plans to increase production to over 37,000 acre-feet per year as of yesterday, nearly 6 times the MAG. A district cannot meet its DFCs while allowing production at that magnitude. Under Chapter 36, rules must be aligned with achieving adopted DFCs. Second, 36.3011B8, where the groundwater in the management area is adequately protected by the district's rules. Where a single entity can regulate its own water production wells and exceed regional MAG levels, groundwater is not adequately protected within the meaning of Chapter 36. Third, 3611B2, failure to properly participate in joint planning processes. Joint planning requires meaningful coordination to achieve adopted DFCs. When production levels materially exceed the adopted MAG, that undermines the joint planning framework established under 36.108 and 36.1132. Additionally, legislative history confirms that the CCSRCD was created solely for aquifer storage and recovery of treated surface water, not as a general groundwater regulatory authority. The executive director recommends dismissal. Respectfully, the statute does not require petitioners to prove violations conclusively at this stage. It requires adequate evidence to show that conditions alleged may exist. The magnitude of production relative to MAG, the structural regulatory concerns, and the statutory limitations together establish more than enough sufficient grounds for a review panel. You're not being asked to issue issues deserve independent review. For the protection of groundwater resources, landowner rights, and the integrity of Texas's preferred method of groundwater management, I respectfully ask you to grant the petition for inquiry. Thank you for your time and consideration.
Thank you very much.
And we have Eric Opiella.
Good morning, Commissioners.
Good morning.
My name's Eric Opiella, and I'm president of South Texans Property Rights Association. STPRA, a nonprofit landowner organization in its 20th year representing over 5 million acres of member land in South Texas. Our members include affected persons. On January 21st, 2026, our board met and unanimously voted to ask me to appear before you in strong support of the petitioners in this matter. We have one request. Refer these petitions for inquiry to a review panel under Water Code Section 36.3011. We recognize that the farmer and rancher petitioners, not guided by counsel, had difficulty crafting a petition to squarely place the issues covered by this section before the Commission, but the evidence in the record raises legitimate issues justifying appointment and referral to a review panel. It's well established that groundwater in place is owned by the surface owner as real property. Chapter 36 was designed to protect that property right with citizen-governed reasonable regulation to ensure that right is not in name only, so that a landowner's neighbors cannot pump them dry. The situation with the Corpus Christi ASRCD breaks that balance. This self-regulation amounts to no regulation at all. The city of Corpus Christi is pumping nearly 6 times the modeled available groundwater for Nueces County. Yet the board of this district until 2 weeks ago consisted entirely of city employees and department heads, all appointed by city council. The city, unique among districts, is the applicant, the pumper, and the regulator. Under that structure, it's impossible for the district to enforce rules designed to achieve the aquifer's desired future conditions when its controlling entity is the one overdrawing the aquifer. It's notable that the rules were not adopted until adjacent landowners began the process for creating a GCD for unincorporated Nueces County. The district is operating outside its legislative scope. Now, after 2 decades as a dormant, non-operating district, Corpus Christi has resurrected it like Lazarus to create a moat around its own production. By annexing non-ASR well fields to assert control over the city's own production, the city is acting outside the scope and mission of a GCD. Despite recent attempts late last October, after over 2 decades, it did not participate in the joint planning process. It failed to update its management plan before the 2nd anniversary of the adoption of DFCs by the GMA. It failed to update its rules to implement the applicable DFCs before the 1st anniversary of the date it updated its management plan with the adopted DFCs. Commissioners, referral is the conservative approach here. It serves the process established under Chapter 36 to review if GCDs are operating appropriately. Dismissal undermines this purpose and sets a dangerous precedent that a municipality can hijack a limited purpose ASR district to avoid independent groundwater regulation, disenfranchising every rural landowner who would otherwise have a voice. The groundwater at issue recharges fractions of an inch every year. The pumping decisions being made now will determine aquifer conditions for decades. Section 363011 exists so that the Commission can act before irreversible harm occurs. We respectfully ask you to appoint a review panel. Thank you.
Thank you very much.
Okay, that's all for the interested persons. We can turn to the ED.
Good morning, Chairman, Commissioner, General Counsel, and Public Interest Counsel. For the record, I'm Cole Malley with the Environmental Law Division. Today with me are Eric Simon and Stephanie Escobar with the Water Availability Division. The ED has reviewed the petitions for inquiry submitted by Tommy Sue Arnold, Scott Brazza, Kelly Lane Harlan, and Wesley Wright, collectively here known as petitioners. The ED has also reviewed the response by Corpus Christi Aquifer Storage and Recovery District and additional responses from the Goliad County Groundwater Conservation District, Christopher P. Cuellar, and Trey Cranford. The petitioners have requested an inquiry based on the following grounds. 1. Failure to adopt and implement rules designed to protect groundwater and achieve DFCs. 2. Failure to adopt and submit a management plan to the Texas Water Development Board. 3. The misapplication of statutory authority. 4. The creation of conflicts of interest. 5. The arbitrary expansion of district boundaries. 6. The failure to coordinate with adjacent jurisdictions and affected landowners. And 7. Failure to provide public transparency. Texas Water Code Section 363011 allows a landowner within a groundwater management area to request that the Commission investigate a district's compliance with certain duties. The Commission may then either dismiss the petition or appoint a review panel to conduct an inquiry. In the review of the PFI, the ED determined that petitioners did not timely file evidence that a copy of the petitions were sent to all GCDs within and adjacent to GMAs 15 and 16 as required by 30 Texas Administrative Code Section 29323E. Furthermore, petitioners did not file a certified statement describing why they believe that a Commission inquiry is necessary as required by 30 Texas Administrative Code Section 29323D. The ED recommends that the petitions be denied due to these procedural deficiencies. Furthermore, the ED determined that petitioners did not submit evidence adequate to show that any of the conditions alleged in the petitions exist as required under Texas Water Code Section 3611B and 30 Texas Administrative Code Section 29323C. Under the Texas Water Code 36-311C, if the evidence is not adequate to show that any of the conditions exist, the commission is directed to dismiss the petition. Therefore, the executive director respectfully recommends the commission dismiss the petitions. Thank you. We're available for questions.
Thank you very much. OPIC?
Hi, yes. Good morning again, Chairwoman, Commissioners, General Counsel, and the Executive Director's attorney and staff. I'm Sheldon Wayne for the Office of Public Interest Counsel. After review of the petitions and the district's response to them, OPIC finds that the evidence put forth by the petitioners is not sufficient to show that any of the statutorily authorized grounds for a petition exist. OPIC must first note that the Texas Water Code and Commission rules only allow a petition for inquiry to be granted if the Commission finds that any one of 9 listed conditions is found to exist. While the petitioners did not explicitly invoke any of the 9 statutory conditions, OPIC identified 4 conditions that may reasonably be ascribed to the petitions, and will briefly discuss each in turn. First, petitioners allege that the district has failed to submit its management plan to the executive administrator of the Texas Water Development Board. The district explains that it has readopted its management plan, and the plan has been submitted to the Texas Water Development Board's executive administrator. Second, petitioners generally allege that the district has failed to participate in the joint planning process required under the Texas Water Code, Section 36.108. The district responds that it attends and participates in the meetings of GMA's groundwater management areas 15 and 16. As evidence, it attaches the affidavit of its general manager, Esteban Ramos. Third, petitioners allege that the groundwater in the management area is not adequately protected by the rules adopted by the district. The district responds that it has created and enforces a comprehensive set of rules that are designed to protect groundwater. Fourth, petitioners allege that the rules adopted by the district are not designed to achieve the adopted DFCs, the desired future conditions. As evidence, they highlight that production has exceeded the modeled available groundwater, also known as the MAG. The district responds that exceedance of the MAG is not dispositive of whether DFCs will be achieved. It notes that the MAG is just one of 5 factors considered when planning for the DFCs. The district further states that its rules are designed to achieve the desired future conditions of the Gulf Coast aquifer and allow it to proactively address changing aquifer conditions, such as by limiting production. Finally, OPIC recognizes that petitioners complain of a number of issues with the district that are not statutorily authorized grounds upon which to base a petition for inquiry. These additional allegations lie outside the scope of what is allowable for consideration here today. Therefore, OPIC has limited its analysis to the conditions identified in statute. By statute, the Commission must dismiss the petitions if it finds that the evidence is not adequate to show that any of the conditions listed in Section 36.3011C of the Texas Water Code exist. Here, petitioners have not provided evidence sufficient to demonstrate that the district has failed to submit its management plan to the executive administrator, has failed to participate in the joint planning process under Section 36.108, that the groundwater in the management area is not adequately protected by the rules adopted by the district, or that the rules adopted by the district are not designed to achieve the adopted desired future conditions. Thus, OPIC respectfully recommends that the Commission dismiss the incident petitions. Thank you, and I'm available for any questions.
Thank you. Mr. Harlan, I believe you have 10 seconds left.
Ma'am, I'd also just like to say this is the only ASRCD in the state or GCD that is operated by a municipality that does the pumping, and that's very important here. So.
Thank you very much. Colleagues, while the Commission does not have significant oversight over groundwater conservation district's management decisions, an affected person may file a petition for inquiry with the Commission for review for 9 reasons. The Commission has 2 options in this matter. The Commission may dismiss the petition if the Commission finds that the evidence is not adequate to show that any of the alleged 9 statutory conditions exist. If the Commission does not dismiss the petition, then the Commission must appoint a review panel to review the petition's allegations. Historically, the Commission has appointed a review panel only when a GCD has not been performing its responsibilities and not in situations regarding disagreements in decisions. While the petitioners have standing as affected persons, I would dismiss the petitions because the evidence is not adequate to show that any of the alleged statutory conditions exist. Many of the complaints are outside of the Commission's jurisdiction. The responses demonstrated that the district's rules and management plan indicate a regulatory framework that appears designed to protect groundwater within the district and the desired future conditions in GMAs 15 and 16. I also question whether the petition meets the minimum contact and notice requirements. With that, I will pause and see what my fellow colleagues have.
I agree with the ED's and OPIC's recommendation to dismiss the petitions and decline to appoint the review panel. Most of the petitioners' concerns are outside the Commission's jurisdiction to review, and the district's response adequately addressed the complaints within the Commission's jurisdiction. While private property rights, I think, are very important, I think that the petitioners also failed to meet procedural requirements. So I would dismiss it.
Commissioner Miller?
I'm in agreement with both of you.
Do I have a motion?
I move that we dismiss the petitions for inquiry against Corpus Christi Aquifer Storage and Recovery Conservation District because the evidence is not adequate to show that any of the alleged statutory conditions exist.
Is there a second?
A second.
All those in favor say aye.
Aye.
The motion passes. Thank you.
Item number 9 is the consideration of the proposed implementation of an expedited compliance order, and the Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I am Amy Sedemeyer of the Enforcement Division, and with me today are Megan Hamilton, also with the Enforcement Division, and Gitanjali Yadav of the Litigation Division. Pending before you is a consideration for approval to implement a new process for handling certain enforcement cases, which includes a streamlined order, the Expedited Compliance Order, or ECO, with established penalties for specified violations in accordance with Texas Water Code Section 7.006. Currently, the time and resources to process simple orders are not significantly less than more complex orders. To ensure sustained success of overall workload management, the division needs a process to handle simple orders in which compliance may be achieved quickly. This ECO is expected to achieve faster compliance and will improve agency efficiency by reducing the time and staff resources necessary to process these enforcement actions. The new process will set reduced penalties in recognition of entities being required to return to compliance more quickly than typical orders. The streamlined process includes generating standardized orders in significantly less time than typical orders. These orders will also require respondents to agree to expedited compliance within 60 days from the date of the agency's settlement offer. The division will initiate this process within programs under TCEQ jurisdiction that have well-established patterns of violation types and will be limited to certain violations that are not for unauthorized releases or discharges. Additionally, we did hold 3 informational meetings, and the response received during those meetings were generally positive. We respectfully request for approval and are available to answer any questions you may have.
All right, thank you. Mary, has anyone signed in on this item?
Yes, Catherine Guerra. I think she's virtual.
Ms. Guerra?
Hi, good morning, Commissioners. Can you hear me?
Yes.
Can.
I'm Catherine Guerra with Public Citizens Texas Office. Public Citizen is a nonprofit consumer advocacy organization with over 1 million members and supporters that champions public interest in the halls of power. Since the agency did not provide any other public comment opportunity on this change to its enforcement process, we want to use this opportunity to highlight our concerns about the proposal. Our concerns center around the lack of transparency and public input. Staff conducted 3 engagement meetings, and I attended one of those sessions with with about 10 other folks. The meeting lasted about 30 minutes. Staff said they'd been working on that program change for 2 years, yet the agency provided what amounted to about an hour and a half of public engagement. We asked whether the agency felt it had adequately engaged both communities and regulated entities on the change, and staff responded it believed it had. The list of the nearly 200 violations proposed for inclusion in the program was not made available to the public during those meetings. The list was only made publicly available as an attachment to this meeting's agenda. The program proposes eliminating consideration of those 200 violations from the commissioner's agenda, which also eliminates the public notification and comment opportunity that affords, as well as the penalty calculation worksheet, and we take issue with any action this agency takes to lessen transparency. We understand that this program aims to divert enforcement cases to expedite compliance, and that we wholly support. During the previous agenda, the Commission adopted agreed orders ranging from 800 to 1,459 days, or 4 years, from investigation to approval. Most included ordering provisions that allowed even more compliance time after the agreed order was signed, even for the respondent who, according to staff, had been unresponsive for over a year. That means ongoing pollution for nearly 4 years. And in contrast, the 60-day compliance deadline proposed for this program seems expeditious. We also hope the program helps the agency address the extensive enforcement backlog. Between January and December of 2025, the agency cleared just 39 backlogged enforcement cases. At that rate, it's going to take 36 years to undo the mess that the agency's own enforcement policies, in part, have contributed to making. Perhaps it's also time to look at the agency's enforcement policies and evaluate how to end the practice of giving polluters several years to voluntarily agree to comply before the agency takes stronger enforcement action. That alone would help expedite the resolution of environmental harms in communities across the state while maintaining the transparency and public input opportunities currently afforded to the public. Absent those opportunities, we'd like to see the number of expedited orders added to the monthly enforcement report, including quantification of those successfully achieving compliance and those that do not, and the amount of the reduced penalties as separate line items. Thank you.
Mary, is anyone else signed in on this item?
No one else is signed in.
OPIC?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and Staff. My name is Eli Martinez. I'm with the Office of Public Interest Counsel, for the record. OPIC has reviewed the proposed process and supports the Office of Compliance and Enforcement's implementation of expedited compliance orders, or ECOs. This process targets straightforward enforcement cases involving common correctable violations, using a streamlined order with preset penalties to achieve quicker compliance while reducing agency workload. ECOs apply to well-established violation types across programs like air quality, petroleum storage products, and public water systems. Penalties are set at 50% of the statutory base amounts, which incorporates a 20% expedited deferral plus this extra 30% incentive, which is lower than traditional calculations or field citations, to encourage rapid settlement. Respondents must correct violations within 60 days of the settlement offer, with options for payment plans or SEPs to maximize accessibility, even for those who are claiming financial hardships. Eligibility is screened during enforcement action referrals. Violations must be on the approved list, fixable in 60 days, exclude releases or remediation needs, and avoid cases with findings orders, OAG involvement, delinquencies, or repeat or unsatisfactory performers. If ineligible cases revert to standard procedures, and this ensures ECOs handle low-risk matters efficiently, without compromising oversight. Our review confirms the legal foundation for this action is appropriate, as Texas Water Code Sections 7.002, 7.053, and 7.070 authorize administrative orders with penalties and corrective actions. No new rules or penalty policy updates are required, though public adoption here aligns with Section 7.006. Importantly, the proposed ECO process would maintain transparency to the public, including Texas registered publication, as is required for traditional agreed orders. The ECO process took place over a fairly long and deliberate period of time, and stakeholder engagement was generally positive. 3 December meetings in Houston, Austin, and Fort Worth raised no major concerns. The impacts of the proposed mechanism are beneficial. For the public, faster compliance means quicker environmental fixes, which reintegrate protection without undue delays. For regulated entities, it ensures predictable, reduced penalties for prompt action, which may promote cooperation. And for our agency, the process will generate increased efficiency, which frees resources for complex cases with more urgent public health and environmental implications. Because this proposal advances the Commission's goals of robust enforcement, resource optimization, is compliant with statutes and in the public interest, and maintains a high degree of transparency to the public, OPIC recommends approval, and I'm available for any questions.
Thank you very much. Well, Amy, I do have one question about how big is the universe of respondents that would meet the criteria for this ECO?
I don't have a number of respondents. However, we did take a look at our current caseload that we have, and we have about 100 orders pending right now where we have not mailed an order out to a respondent, where we have the intention to start the process upon approval, hoping immediately to engage with those respondents to see if they are interested in this program. We have another 300 that we have already provided a proposed order. That's a little bit more of a nuanced situation where we have to look at why they're not signed yet and that sort of thing. But we immediately will tackle those 100 that we have.
Right. Thank you. Commissioners, do you have any questions for Amy?
No questions. I just want to say, I mean, it has always been TCEQ's policy belief to get companies into compliance. And I think anything we can do to get companies into compliance sooner is a great step forward. And I really appreciate your guys' thinking on this and working diligently on it.
Compliance first. I appreciate the work and the thought that's gone into looking for ways to streamline and move this enforcement docket forward. I'm prepared to move forward with the approval of the proposal. Do I have a motion?
I move that we approve the implementation of the expedited compliance order process as recommended by the Executive Director.
Do I have a second?
I second.
All those in favor say aye.
Aye.
Aye. Thank you.
That takes us to the enforcement docket, which are items 10 through 20, and the Executive Director's staff is here to present these matters.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Megan Hamilton of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 10 through 20. The total assessed administrative penalties are $271,077, with $51,342.27 deferred, $81,170 applied towards supplemental environmental projects, and $138,564.73 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you very much. Mary, do you have anyone signed in on these items?
No one is signed in.
OPIC?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Is that the last time you're talking at agenda? As always, I'd like to express my appreciation for the work that goes into developing and negotiating these orders before they come to us. I'm prepared to move forward with adoption on all orders. Colleagues?
Same.
Do you have a motion?
I move that we adopt items 10 through 20 as recommended by the Executive Director.
Do I have a second?
Second.
All those in favor say aye.
Aye.
Aye. Thank you. The motion passes.
Okay, item 21 is our public comment session. We don't currently have anyone signed in to speak, but we'll pause here to see if there's anyone in the audience that wanted to address the commission. Seeing none, we'll move on to executive session. Those items, the commission will be meeting in closed session in room 4222 in Building F at, shall we say,
11:30.
11:30, as permitted by the Open Meetings Act, including Texas Government Code Sections 551.071 and 074, to take up and consider matters pursuant to items 22 through 25 as posted and noticed.
Thank you. This meeting stands in recess. The time is 11:08 a.m.
The commission met in room 4222 of Building F for closed session from 11:34 a.m. until 12:07 p.m. on item numbers 23 and 24 as posted and noticed pursuant to Texas Government Code Section 551074. No action was taken. The agenda stands adjourned, and the time is 12:21.